response. Let me see if I can break this down for everybody. Ms. Reynolds, you're saying there's a change of circumstance.
I'm
sorry, Ms. Lemon.
Sure.
Ms. Lemon. Forgive me. I'm looking down at one of the pleadings and it says Reynolds versus Reynolds. So that's why I'm looking down, looking at my notes and reading. And forgive me, but the court filings and the dockets will always say Reynolds. They don't change it to Lemon. It's what it was incepted as. So what we've got here is the basis for your change of circumstance is essentially that he changed jobs and that he the overnights went from 182.5 to 185 versus 180. That's your pleading.
No, that is not. To clarify that, if you look at my pleading, it says that my job has changed, his job has changed, and that the original agreement was made under false information.
Well, the original agreement has been ratified by the court, so I'm stuck with it. Okay. What is the change in your job?
I was a full-time student.
Okay.
And doing real estate, and as we know, real estate has tanked completely. So have been trying to find a job now that I have graduated, but because of the, corrupt nature of the court, there's a felony on my record, and that should not be there. And so I am struggling to gain employment.
All right. Well, my problem is this. I need a major change of circumstance to review child support. That's been the problem. That's been the problem all along. So you're saying you don't have an income now?
Correct. And Dave moved to Tennessee. I think that's pretty major too. He bought a house in Tennessee.
That's not what his pleading says.
Excuse me?
Where does Mr. Reynolds live? He lives according to his response, he lives here in Grand Rapids.
When I requested this entire child support review, he bought a house in Tennessee, and he still owns that house in Tennessee.
He can own a house in Tennessee, but if he's living here in Grand Rapids, that's not a change.
Well,
All right, guys, buckle up, because this courtroom showdown starts with confusion right out of the gate. The judge is looking at the filings, fumbling between names, and already irritated with the mess on the record. Miss Lemon comes out swinging, saying the whole agreement was based on false information. She claims her job has changed, his job has changed, and everything about the original deal stinks of corruption. And just when you think it's straightforward, she drops the bomb about a felony on her record, saying it's making her unemployable. Already the tension is boiling.
The only question here is, I need to know what his income changed because the job changed. So what information I need is this. I need information from his current contract. And if it is the same income, we do not have a change of circumstance, and we're stuck with the 36 months by law. That's my explanation, Ms. Lemon. That's why I tried to explain this. I'm like, I don't have the requisite change of circumstance to review child support at this time. You signed a contract in June of 2022. Essentially,
based on the information that David Reynolds was going to be, I was forced to sign that, claiming that that was the only way I could see my kids.
Unfortunately, but there was a lot to that agreement. They waived arrears.
Including the fact that I would be able to see my kids, because otherwise I would not be able to.
And you are seeing your children, correct? You are seeing your child? Yeah, okay, then.
Only because I agreed to sign that.
You got the benefit of the bargain. And that's my problem. I don't have the requisite legal change of circumstance to review this unless his income increased. If his income increased, I will review this. So what I need is I'm going to reserve on that because I want that information. Once I get it, I'll issue an opinion as to whether there's a change of circumstance or not. Mr.
And so he does not have the kid. He does not have her 50-50. And nowhere in my pleadings did I say it's about a 2-day difference. That was a benefit that I was giving him to try to resolve things outside of court.
But again, her pleading says 2 overnights.
I know that's what her pleading
said. It does not. Where does the pleading say that he only has 2 additional overnights? Please tell me where the pleadings say he only has 2 overnights.
I will look it up right now.
That's what I'm looking up too, because I know that I read it in your pleading.
My request was for the child support to be based on 2 different overnights, but that was because of a conversation I had with Dave, which he claimed he would be willing to do if I would swap.
Minor daughter Callie spends a minimum of 184 overnights with the plaintiff. That's what it says.
A minimum.
That's what your number 3 is. That's where I got the numbers from.
A minimum. That is not saying there's only a 2-day difference.
And I think you have a typo. Yeah, I think you have a typo. You probably meant defendant, but Oh, no,
No,
you
I
are the
didn't.
plaintiff.
No,
I'm
I
sorry.
didn't. I meant the
Either-
plaintiff.
either-
Now listen to this, guys. The judge isn't buying it so easily. He wants proof, cold hard facts, not just accusations. Miss Lemon argues that her ex, Dave Reynolds, moved to Tennessee, bought a house, and that's a game changer. But the judge fires back. Owning a house doesn't equal a change of circumstance if the guy is still living in Grand Rapids. He makes it crystal clear. If there's no major income change, the law ties his hands. Miss Lemon insists she was forced to sign the original deal just to see her kids. The drama is already heating up.
I am the
You
plaintiff.
said 184 overnights.
Either
That's
one,
what you
your
said.
allegation number 3 indicates you guys have almost the same parenting time that was ordered in the previous order.
No,
That's your own
There's nowhere
that's
in
your
there
own
doesn't say that we
number
have the
3.
same parenting
Minor
time.
daughter Kaliana Reynolds spends a minimum of 184 overnights with the plaintiff.
But yeah, that does not say that's a equal split by any stretch of the imagination. Nowhere there does it say that Dave then has 180
yes, it
some.
does, Miss Lemon.
No,
yes,
it does
So
not.
I will reserve. Get me that contract. Let me see what the pay is. I will note the pay in the order. I'm going to let her know what that contract says, and if it says the $500,000 that you're alleging, there's no change of circumstance. Matter of fact, his pay went down $6,000. So,
Thank you very much, Your Honor.
All right. Have a good morning, everyone.
Have a
So
great
just
day.
to
I'll
make
reserve
sure,
after I see that.
the additional proofs that were requested, because I know last time that we sat before you, you would not allow me to show the video. That was very clear evidence, even though Jude himself had the exculpatory evidence.
Have you been in front of me before? I don't
Yes.
remember you guys. Okay.
Absolutely, we've been in front of you before.
All right. You mostly
And
been in front
you
of
would
Judge
not
Semitis.
allow me to present anything, just like now.
Okay. Well, you've presented what you presented. That's what you've presented it by your motion.
No,
I
no,
read
my
your
motion
motion.
very clearly
Matter of fact,
says
I
that
read
I
it
have a
in
change
several-
of job.
Okay.
It very clearly says I have a change, both in my student status and in my job, that the father has a change, that it's not remained 50-50.
All right. Again, have a good morning. I'm going to reserve, and I will issue it when I look at his income. Have a good morning.
Thank you very
Thank
much,
you,
Your Honor.
everybody.
Rebecca Aldrich versus Mark Aldrich.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Podolsky on behalf of defendant. This matter is before the court on the plaintiff's motion for contempt, and the defendant has filed an answer. You did receive the answer, Mr. Todd?
I have, Your Honor.
Okay. Anything else that you'd like to add, Mr. Todd?
Your Honor, I will largely rely upon my motion, but even since we filed this motion, there have been substantial issues on this.
It's all right. This is where it gets wild. Miss Lemon pushes hard, arguing over parenting time, overnights, and numbers in the pleadings. The judge flips through the documents and calls her out on inconsistencies. He points out typos, minimum overnight numbers, and says the case is basically the same as before. But Miss Lemon won't back down. She swears Dave is gaming the system. Finally, the judge shuts it down, saying he'll reserve until he gets proof of Dave's contract and actual pay numbers. It's a deadlock for now, but the tension in that courtroom is off the charts.
November 24th, Mr. Aldrich gave my client a gift, which was a heart stating "to my wife." The card attached, or the box attached, stated "2 honey buns from I will," and there was a poem inside of this gift. Additionally, there have been consistent messages outside of our family wizard and outside of the scope of relating to the child. For example, there were substantial messages on January 9th about Mr. Aldrich's Bible study and asking why my client is ripping the family apart. We have tried to resolve this peacefully and tried to prevent it from going to this point, but I don't think this is just not resolving itself. So we are respectfully requesting he be held in contempt. We're respectfully requesting attorney fees for having to file this motion.
Thank you, Your Honor. As we've stated in our response, the plaintiff in this matter is not telling the court the complete truth. She often initiates these conversations. They are often not about the child. They have been about mediation, resolving issues. And when conversations break down, she's not getting what she wants. Then she files a motion for contempt and does not include her part in these conversations. I liken it to the behavior in a PPO. You can't get a PPO against somebody and then initiate that contact and ask that the PPO be violated. That's exactly what's happening here. She's calling, she's texting, she's using Our Family Wizard, but not including those sides of the conversations in her motion. We mediate this case on Thursday. We have repeatedly asked for co-parenting counseling so these parties can get on the same page with parenting their minor child. This is a family with deep spiritual roots. They are trying to guide.
Just when you think it's over, bam, another case gets dragged in. Aldrich versus Aldrich. And guys, this one is straight up bizarre. The plaintiff's lawyer says the defendant crossed the line with creepy gifts, a heart-shaped present, and even a poem to his ex. Not only that, but there's non-stop messaging outside the official family app, bringing religion, Bible study, and guilt trips into the mix. It's the kind of toxic back and forth that looks less like co-parenting and more like psychological warfare. The lawyer wants contempt charges and attorney fees to put the hammer down.
Their child spiritually in her religion through this very difficult time. My client has simply been trying to explain to the plaintiff what he's trying to do as a parent, how he's been feeling, how his brain works in these conversations when she gets angry with him because she's not getting what she wants. And then when he tries to explain this to her, she gets upset and files this motion. We do not believe that there should be any sort of contempt because this is just simply two people who are unfortunately going through a divorce. They're trying to navigate this process, having not done it before. And this is just simply not a case for contempt here, especially with plaintiff's actions not telling the court the complete truth. So we're asking the court to deny the request in its entirety, award costs and attorney fees, and we'll proceed forward with mediation on Thursday.
Well, looks like you need to proceed on mediation on Thursday, but court does note that it does appear that there are disputed issues in this particular case that need to be addressed and to be, again, flushed out at that particular time. So we'll contact both of the offices and set a time for a hearing in this particular matter if you're not able to resolve things at mediation.
Yep.
Anything else, Mr. Todd?
Your Honor, do you need me to prepare an order, or will the court just set that?
No, we'll just set the matter for a hearing and be in touch with both of you.
Okay. Thank you, Your Honor.
Okay. Thank you. Have a good day.
You as well.
But here's the kicker. When the defense fires back, they flip the whole story on its head. They accuse the plaintiff of being the one who starts these conversations, dragging things into emotional chaos, and then running to the court when it doesn't go her way. They say this is no contempt case. It's just a messy divorce spiraling out of control. The judge listens, stays calm, and punts it to mediation. No knockout punch, no dramatic ending. Just a cliffhanger for the next round. And that, my friends, is how messy and downright brutal these family court battles get.